All right, welcome back. So this is the beginning of the third chapter. So we're done with constitutional foundations, which we looked at in quite a bit of detail, right? And now we're focusing on delegation and rulemaking, which is, in other words, how does a tribunal get the power to make a decision in the first place? So chapter 1, we looked at an introduction to administrative law, which was frankly outstanding in that book for the number of pages it covered, right? So we looked at all the things we normally look at. So we looked at, right, the power, jurisdiction, procedural fairness, constitution, and eventually the standard of review, very briefly, which are all the things we'll cover in this class. Chapter 3, right? Chapter 2 covered constitutional foundations, as we said, so whether a bunch of jurisdictional issues oftentimes. Then we looked at how the tribunal gets the power to apply the Constitution of the Charter, which is a threshold issue, of course, that will always apply. So if you have a claim that is constitutional in nature before a tribunal, so someone says Section 7 wasn't respected, first thing you've got to decide is whether the Constitution, right, can be applied by that decision maker. Not whether it applies, because it might not, right? Sometimes people go to court and they lose, right? So you can go to court and say Section 7 was violated, and the court can say you're wrong, you lose. So you have to determine that. But before that, you have to determine whether the Constitution applies in the first place. Whether the Constitution, can be applied in the first place by that administrative decision maker. Similar issues that we have here is the delegation and rulemaking, right? You go to court, you seek judicial review of a decision that's been made. Say it's a decision, as in my earlier example, to give someone a license. Then you say that decision somehow is problematic, right? So it wasn't done right because of procedural fairness, doesn't respect the Constitution, whatever it is. You go to court, seek judicial review, then the court reviews it, applies the standard of review, which we saw, which we'll see in more detail, reasonableness or correctness, right? All that. One of the things the court is going to assess is whether or not the tribunal had the power to make that decision in the first place. One of the reasons why a decision might be problematic is because it is illegal, because the tribunal made a decision that it didn't have the power to make. So, some bureaucrat, whoever they are, can't deny you a license to a pipeline, or a right to a pipeline or a license, right? Whatever it is. Unless they have the ability to do that in the first place. There has to be a law somewhere that says this is the guy that's going to do that. If it's someone else, they can issue you a piece of paper, but it's worthless, right? Even if it says license on it, because that person does not have the legal authority to do that. And it's one of the reasons why a decision might be invalidated upon judicial review by, say, a court. So you can go to court and say, this guy did not have that power, or did not have that broad a power. So it might be that the guy had the power to issue a license, but only a specific group of people. You're not within it, right? That decision remains illegal. The court will review it and cancel it, right? Quash it, as we said. So that can be a threshold issue again, as to whether or not you have the administrative decision maker has the power to make that decision in the first place. As we'll see, it has to be delegated in the first place, right? It has to come from somewhere. One thing that's mentioned at, I think, the third page of the chapter, which is extremely well put, is that an administrative tribunal will not have, quote, inherent jurisdiction, unquote. What does that mean? It means that they don't have a default power. So you'll recall we talked a lot about the superior court. We set the superior court as inherent jurisdiction, right? And so, if you don't know where to go, you go to superior court. That's what the Constitution says. Constitution says you have to have somewhere to go. If you don't know where that somewhere is, if there's no other law that says that that somewhere is somewhere else, then you go to the superior court. When you go to the superior court has the jurisdiction, the ability to hear your claim because it has inherent jurisdiction, because the Constitution says it's the default place, and so it has the default ability to consider your claim. You don't need a statute that says the Superior Court can decide claims on a personal injury. It has inherent jurisdiction, default jurisdiction, therefore, that by default, without anything to that effect, includes a personal injury. An administrative tribunal does not have inherent jurisdiction. It's a good way to put it because it's simple, and it's what I just said, because it's not the Superior Court. So the car tribunal, again, only has the power to hear claims on cars, and that's because it's not the Superior Court. So you have to look somewhere to find the power of the car tribunal to make decisions on car accidents. Usually that will be the enabling statute, which will be the Car Tribunal Act or the Car Accident Act. And that limits the power of the tribunal. So you can't go before the tribunal and ask for anything. So you can't go there and say, I want damages for something, like so say a car, right, veers off the road and burns the house down. You can't just say, this is a car accident, therefore I go to the car tribunal. It doesn't work that way. You have to have that power in the first place. So you have to look at the statute and say, what does the car tribunal do in the first place? Right? What's its jurisdiction? And then you have to determine whether or not your claim, the house burned down, that's the claim, falls within that jurisdiction, such that the tribunal has the power to consider it. So, jurisdiction is inherently limited. It has to have the power. And it has that power by statute. And you always have to look at whether or not the statute includes that power. And that's something, as I said, that can be a ground for judicial review. It's the converse effect of what I said. Once it's done wrong, right? Once it's done beyond jurisdiction, right? If the tribunal doesn't respect what it has the right to do, then that's one of the reasons you can go to court and have the thing canceled. Why do we call that delegation? Because that power has to come from somewhere, right? Which, as I said, is the statute. But why does the statute have the power in the first place? And the answer is because of the Constitution. But the Constitution gives it to elected people. Again, the Constitution's God, right? There's no power that doesn't come from the Constitution. Constitution says, these are the people we allow to pass laws. They're legislators. So they get elected this way, and as I said in the last capsule, they can do whatever they want. If they meet the procedural rules, and they respect whatever applies, say the Charter, they can pass any law they want, even if it's really bad. That power comes from the Constitution. Eventually it gets to the administrative decision maker, and that's delegation. Then the legislators have that divine power by virtue of the Constitution to pass laws. They use that power to pass a law that says the car tribunal will hear claims on car accidents. That's delegation. They are delegating their power to the car tribunal. And then the car tribunal has that power. That's why we call it delegation. Another thing that which is second portion, rulemaking, that the legislators could do is they could say the car tribunal, once it's created, will have really smart people in it that will know about car accidents. Therefore, it will be better than we are at passing laws on car accidents. And therefore, what we'll do is we'll allow the tribunal to make its own rules. So we'll create the car commission within the car tribunal, which will make rules regarding car accidents, and that's also allowed. And you're delegating their rulemaking power. So you're not delegating, right, decision-making power, which the car tribunal has. Car tribunal hears claims on car accidents. It looks at any law. That's what the statute says. So car accident tribunal is going to look at the Car Accident Act, which gives it that power. And then if it's not in there, it will look at other laws and apply them to the specific facts of a car accident. That is decision-making power that's delegated. Rule-making power is the car commission within the car tribunal will make up the rules. And so they won't be in any law. They won't be in the Car Accident Act. They will be in some other thing that will be created by the car commission, which are called regulations. And they're actually called regulations in the real world. That's what regulations mean every time you're citing them pursuant to the McGill Cite Guide. And so they will enact their own rules. Again, that power has got to come from somewhere, which is a constitution. So, again, constitution's God gives the power to the legislators to make the rules. Legislators then delegate the power to make the rules to the car commission. And you see there, right, both delegation and rulemaking power. And again, that's allowed. It's allowed because the regulations, in my example, are passed pursuant to a law. If the car commission is properly given the power to create the rules, then the rules will be valid because they are enacted pursuant to a power. And power there is synonymous with a law that creates that power. And when that law is otherwise valid, the regulations are. So 142 is where you have, and again, all these 141 to 143 are extremely important, but 142 is where you have the quote I gave you. It's to the effect that, right, to the effect that the tribunal does not have inherent jurisdiction. So there's a reiteration of two principles that we saw already also at page 142. First, the power that's being delegated to an administrative decision maker has to exist in the first place. And again, you look at the Constitution. We covered that, right? So one of the things the Constitution does is it gives the power to, again, the federal and provincial governments, the legislators, the people who pass the laws. It doesn't give them the power to pass any laws, right? There are specific heads of power. There's some stuff that's with the federal government. There's some stuff that's with the provincial governments. If the federal government doesn't respect that, passes a law on a subject matter of provincial jurisdiction, that law is invalid. It's ultra virus, right? Because federal government passed a law in a way that was procedurally appropriate, but did not have the constitutional authority to do that in the first place. That's an issue that's raised there, right? You have to have that power in the first place. So if, say, instead the federal government delegates that power to the car tribunal, the car tribunal will also make a decision that's illegal, because that power has to come from somewhere in the first place, again, which is the Constitution, if there's no power there in the first place. So say the car tribunal makes a decision on a subject matter of provincial jurisdiction, that decision's invalid, because the car tribunal gets its authority from the federal government, and the federal government doesn't have that authority in the first place. And so that makes the decision of the car tribunal ultra virus. Different from within the statute. Another thing the car tribunal do is make a decision that it doesn't have the power to make in the statute. So the statute might say the car tribunal will decide only pecuniary matters. Car tribunal decides the criminal law, say, which is not a pecuniary matter. Then the car tribunal would also make a decision that's illegal, and also because it's not within its jurisdiction, but that's different. There's jurisdiction within the statute. Car tribunal has to have the power, by virtue of its enabling statute, which is a Car Accident Act, to make that decision. If that power is not in there, it doesn't have it. But, right, even if it's in the statute, when you go upstream all the way to the Constitution, it has to exist. So it has to come from the Constitution to the federal government to the Car Tribunal as well. Second issue that's mentioned, right, discretionary decisions, as we spent quite a bit of time on in the previous capsule, are not fully discretionary. So even if the power is drafted extremely broadly, so even if it says this person has the power to approve pipelines, which is extremely broad, right? That would mean they could approve them without procedural fairness, would mean they could approve them discriminatorily, whatever it is. It doesn't work that way. You have obligations that apply regardless to respect procedural fairness, right? And therefore, right, that is subject to these obligations. And so, right, you have to determine still whether that discretionary power was exercised discriminatorily pursuant to the charter or whether it respected procedural fairness. When the statute provides for criteria, then they apply. So the statute says, here are the 5 things that the bureaucrat has to consider in issuing a license. Then they have to do that. Because again, they get the power from the statute. So they have to consider the 5 things. And if they don't, then their decision is potentially invalid. And you can claim that upon judicial review. You can go to court and say, this decision is not legal, it's not valid because the decision maker did not respect their statute, did not do what they had to do pursuant to the statute. Then you have the issue of subdelegation, right? And we covered that very briefly already, right? The default rule is that you cannot redelegate power. So the car tribunal gets its power from the federal government in the first place, right? Or it would be the provincial government by virtue of the Constitution. But it gets its power from the government in the first place, right? Then cannot subdelegate that power. It can't create the car accident tribunal number 2 and say, this new body we just created is a car tribunal, right? The car tribunal created that, created car tribunal number 2, will decide a sub-range of matters. So some claims, which frankly we're getting sick of, right, within our tribunal, we'll send somewhere else, and we're creating that somewhere. Generally, the default rule, which you have in Latin, which I won't repeat, right, is that you can't do that. It doesn't work that way. So you cannot redelegate a power. It can only be delegated once. And that makes sense because the once is where it comes from in the first place. So the government can delegate it to the car tribunal, and it's good because the government gets it from the Constitution in the first place. Then the car tribunal redelegating it, right, doesn't get it from the Constitution, isn't subject to democratic, right, checks and balances, and might not even be within the intent of the people who are, right? The government created the car accident tribunal in the first place without anticipating that something else than the car accident tribunal would exercise that power in the first place. And there's all the issues as to, right, again, democratic legitimacy and all that, which we always have with administrative law, and therefore we prevent subdelegation. As you'll see from this section of the book, 143 and following, it's actually more complicated than that. Sometimes you can, and that's if the presumption's rebutted. So the fact that a delegated power cannot be redelegated or subdelegated is an interpretive presumption, quote unquote, page 144. It can be rebutted. So if the statute says the car accident tribunal can delegate that power if it wishes to, then it can, right? The default rule can be rebutted by, right, the people who have the power from God, which are the legislators. So if it's rebutted in that case expressly, it doesn't apply. It can also be done implicitly And implicitly means the same thing we saw previously in the term, right? So you can say the car accident tribunal, again, this is just one example, would have the plenary power to exercise all powers to efficiently govern itself and ensure that proceedings are disposed of, right? Then that might imply that it's meant to have a very, very broad range of powers, and therefore also the power to delegate that power, or subdelegate a portion of that power, to some other body that it might create. 144, that does not apply when the power is essentially purely bureaucratic in nature. So if you have a power that's very simple, so say everyone who completes steps 1 to 5 gets a license, and step 1 to 5 are not subjective at all. There is no legal interpretation going on. It's not hard to apply it to the facts. You just look at it and it applies itself. Then that does not fall within the rule, could be delegated. Because really could be exercised by anyone because it's easy. Right? And that's as opposed to a power that would require more critical thinking, for example, right? Which is most of administrative law, right? You're either applying a statute, so you're applying it to the facts, assessing the facts, right? Or you're making a decision that has an impact on people's rights and obligations that is discretionary in nature. And therefore, discretionary means you consider whatever you want, but you consider something, right? If it's not that repetitive power, therefore the presumption would apply. Then you have an issue as to, on delegation, the minister, quote unquote. And there's a special rule which is covered in depth in the book, which you really don't have to focus on. But essentially the rule is the minister can delegate to senior officials. That's the only important thing. So if it's a minister, they can delegate their power to senior officials. And that's by virtue of the way statutes work, right? Usually you'll have a power in the statute that's given to the minister. So for example, the Minister of Immigration has the power to make a discretionary decision not to apply the law and send someone back to their country. So person doesn't meet the statutory criteria. So there's a test for, right, there's a provision in the statute, right, the Immigration and Refugee Protection Act is what it's called, right? So let's use that example. That statute says the person, we won't send them back home if they'll die, ostensibly because we think it's not a good idea. The statute also says the minister has the discretionary power to waive the application of that section. So if someone does not meet that section, in other words, they don't meet the criteria for showing they'll die, therefore they're sent back to their country. Minister has the power to waive the application of that. So it can say, I won't send them back by virtue of my discretionary power, right? That's an example of the minister exercising discretion. As you can imagine, there are a lot of people getting sent back to other countries. So, of course, the actual minister, the person who got elected and has that title, will not themselves make that decision, right? They won't review the files themselves. They would do that for years, and therefore, right, they have the ability to delegate that power to senior officials. And that's by virtue of the fact that, right, usually the statute will provide for a power of the minister without an actual expectation that they will or can exercise it themselves. And last issue with that, right, to the extent the minister does that, does not have to do it in writing. So otherwise, it would have to be in writing. So if you, again, you can't subdelegate power by default. If it turns out that you can't, because you meet the exception, because it's implied or expressly given to you, the ability to subdelegate, generally you need a written thing right? Which just makes sense, right? Because a statute is a written thing in the first place. So car accident tribunal gets its authority by virtue of a statute, which is a written thing. If it can subdelegate, you'd expect the same thing. So you'd expect that to be in writing, and that's because we want to know the bounds, right? We want that piece of writing to say, this is its power, and the use of that is so that someone can show up and say, that decision is not within that power. So you have to define the contours of that power in the first place, and that's why it has to be in writing. If it's the minister in the example I gave, there's an exception, and they don't have to do that in writing. Probably for the same policy reasons we just mentioned. Okay, last thing is pages 151 and following. Last thing for this capsule, we'll have another one, is what counts as a law, right, for the purposes generally of applying the charter. So if you have a decision, right, if you have rulemaking authority being delegated, then the rules which are enacted pursuant to that authority will be subject to the Constitution as if they were laws, which makes sense, right? If Parliament passes a law, it's subject to the Charter, so you can go to court and try to have it invalidated. If Parliament delegates that power to an administrative body, then it wouldn't be fair if you didn't have the same thing. So that's subject to the Charter. Same thing applies for rulemaking authority. However, you have kind of a threshold issue as to what counts as a rule, right? So if it's something, something more akin to an internal directive, right? A rule book for how people behave in the office, most likely it wouldn't count as, right, a rule within that power. Even though you can go upstream and find perhaps, right, the ability to enact these rules pursuant to indirectly some statutory or other authority document. So it has to be general enough, the rule, for it to count as a rule, and therefore be subject to, say, the Charter, and that makes sense, right? So it has to be of somewhat general applicability, which is generally how laws work, right? So if a law says you can't burn a red light, that's of general applicability. It doesn't apply just that morning to that person, in which case it wouldn't be. It applies to everyone, right, more generally. And that's it for this capsule. There will be a last one for this week.